In multiple interviews, the governor has indicated that the legislature could authorize another method for carrying out capital punishments in addition to lethal injection. Nitrogen hypoxia is an alternative method for carrying out capital punishments that has been made available in other states. The legislation introduced by Representative Plummer and I will authorize the state of Ohio to utilize nitrogen hypoxia in addition to lethal injection, and direct that it shall be used in instances where lethal injection is not an available means of carrying out a capital sentence. In addition, this legislation will restore the confidentiality protections which the Ohio Revised Code previously gave to manufacturers and suppliers of drugs used in lethal injections. It will extend those protections to nitrogen hypoxia, and it will also make clear that violating these confidentiality provisions surrounding lethal injection and nitrogen hypoxia materials would be a fourth-degree misdemeanor. It's important to note that this legislation does not change the manner or frequency in which capital punishments are imposed by Ohio juries. However, capital punishment is the law of the land today. The law should be followed, and existing duly enacted capital punishment should be carried out to give the victims' families the justice and finality that they deserve. This bill will provide the legal framework for that to occur, and we are very grateful to have the support of the Ohio Prosecuting Attorneys Association, who's here with us today, and especially our great Attorney General, Dave Yost, who will now share his thoughts on this issue.
Thank you, Representative Stewart. In 1977, a man named Bob Hand got into financial difficulty. He killed his wife, Donna, for life insurance proceeds, and he got away with it. In 1979, again strapped for cash, Bob Hand killed his second wife, Lori, right here in Columbus. Somehow his third wife managed to get a divorce before she too became a source of life insurance proceeds for him. But in 2002, he conspired with a friend of his named Lonnie Welch to kill his fourth wife, Jill Hand. And then he killed Lonnie Welch to make sure that he couldn't testify against him. 4 murders. Cold blood over nothing more than money over a period of 25 years. In 2003, I prosecuted Bob Hand. I stood in front of the jury in the Delaware County Court of Common Pleas, and I asked the jurors to listen to the evidence, listen to the mitigation, and hear about Bob Hand's life, and to return a death penalty. This is not an easy thing. This is not a casual thing. It's not a political football. It's one of the hardest things I've ever had to do, to ask my fellow citizens to return a verdict that would result in the death of another human being, but they rose to the occasion, considered the evidence, and did return a capital verdict. He then exhausted his appeals in 2018, state system, federal system, all the way to the United States Supreme Court. Since 2018, he's had nothing left to argue about, and yet he still sits on death row 21 years later. Later this year, it'll be 21 years. I support this bill, saying that the law of Ohio should be thwarted, be able to be thwarted, because pharmaceutical companies don't want to sell the chemicals. It is an abdication of the sovereignty of the state of Ohio, which still has this law on its books. The average time on death row for a death row inmate now is nearly 21 years. This book, which we produce every year by mandate of the General Assembly, details case after case of people who are the worst of the worst, whose sentences are deserved, who are still sitting and waiting their day of justice. This is an exercise in democracy. I am aware of the moral weight of this debate. But this is the law of the land. If we wish to break the promises that we made to the families of all these victims over all these years, if we wish to not keep faith with the jurors that we asked to take this heavy weight on to make a judgment, then we owe it to our society and to all those that are involved to own our decision to change our minds. I recognize that there are people with legitimate and deeply held beliefs that don't think we should have capital punishment. I respectfully disagree with that, having been a prosecutor, having actually had to handle one of these cases. But if our democratic processes are such that we decide that we should break our promise, break faith with where we have been and what we have told society, then we at least owe it to ourselves and to everyone else, including those jurors who had to look deep in their souls to render this verdict and other verdicts like it, to own it and to say we've changed our minds and to express the reasons. The status quo is unacceptable, where we're neither taking responsibility for the judgments, nor taking responsibility for, if it proves that way, our preference to avoid the unpleasant nature of this debate.